That this event is taking place and that the book is done. Congratulations. I have the honor of moderating this next panel and the consciousness that we're already 15 minutes behind. And there's a fairly hard end to the day's events. So all of my wonderful, gracious panelists have agreed to speak for no more than 17 and a half minutes. We may have time for questions, we may not, but you can always contact them. I will tell you who they are so that you'll know how to reach them. Professor Richard McAdams is the Deputy Dean and Bernard D. Meltzer Professor of Law at the University of Chicago. He writes on criminal law and procedure, social norms, the expressive function of law, inequality, and law in literature. He's the author of The Expressive Powers of Law from Harvard University Press and co-editor of Fairness in Law and Economics. He has served as a member of the National Science Foundation Advisory Panel for Law and Social Sciences, the editorial board of the Annual Review of Law and Social Science, and the board of directors of the American Law and Economics Association. Our next speaker is Professor Edward Rock, the Martin Lipton Professor of Law at New York University Law School. Professor Rock's main areas of teaching and research are corporate law and corporate governance. In his 50 or so articles, he's written about poison pills, politics and corporate law, hedge funds, corporate voting, proxy access, corporate federalism, and mergers and acquisitions, among other things. In addition to teaching and research, Professor Rock is the director of NYU's Institute for Corporate Governance and Finance. Our next speaker, Professor Harlan Cohen, is the Gabriel M. Wilner UGA Foundation Professor in International Law and the faculty co-director of the Dean Rusk International Law Center at the University of Georgia School of Law. Professor Cohen specializes in international law, national security law, and legal history. His scholarship has appeared in George Washington, Tulane, Iowa, New York University Law Reviews, and the Yale, Berkeley, NYU, and Michigan Journals of International Law, amongst other places. In addition to his research and teaching at the University of Georgia, Professor Cohen's a member of the board of editors of the American Journal of International Law and a member of the American Law Institute. And he currently serves as vice chair of the American Society of International Law's International Legal Theory Interest Group. And finally, Professor Amy Sepinwall is an associate professor of legal studies and business ethics at the Wharton School at the University of Pennsylvania. Professor Sepinwall's research interests include corporate constitutional rights, gender and racial justice, individual and collective responsibility for corporate and financial wrongdoing. Amongst her numerous honors, Professor Sepinwall has been awarded the Distinguished Proceedings Award from the Academy of Legal Studies and Business, the Virginia Moore Best Ethics Paper Award from the Academy of Legal Studies and Business, and the Charlotte Newcomb Dissertation Fellowship from the Woodrow Wilson Foundation. So a highly distinguished panel. I will stop talking about them and let them talk to you. Thank you very much.
This is a great event for a really great magisterial book, and I'm very proud to be part of it. I was asked in my invitation, I think, to address the one thing it makes sense for me to come here to talk about, given my unfamiliarity with halakha before reading this book, and that is the expressive function of law, or the expressive powers of law. And so that's my role here today, to examine Professor Simon's book from the perspective of that body of literature. And my comments will go a little bit back and forth in that I kind of, I'm not certain about what the exact connection is. I tried to be critical of some of the points that I made, and that led me to other points. So to begin, there are many things in the halakha that are expressive in that they're not enforced. And the one that struck me was the death penalty as a sentence for certain crimes. Now, in a sense, all criminal punishment could be described as expressive in that it's not merely the infliction of harsh treatment on a rule violator, but an expression of harsh treatment on a rule violator for the purpose of condemning them and or that kind of behavior. But a criminal sanction is even more purely expressive when it's not actually imposed. It's simply a statutory rule that says that there's some punishment for this, which identifies how serious the offense is, and yet it isn't actually used. And in the description of Jewish law, in capital punishment seems to be expressive in this purely symbolic sense. First, there are procedures that made it impossible to actually implement it. And then at the end of the book, Chaim describes as possibly just rhetorical some rabbinic claims that certain behavior deserved capital punishment. Now, so those are examples of law as expressive. But the presence of these examples doesn't tell us if the expressive theories of law, the ones I've contributed to and responded to, have any bearing on our understanding of Jewish law. So much of the theory on the expressive powers of law, including my own, seeks to explain how law has the power to influence behavior by mere expression. And I wondered, could these theories be at all illuminating for the halakha? Now, to explain, this expressive literature views law as doing more than threatening sanctions, and it views law as having an effect on people's behavior also for more than what the psychologists or sociologists might call the legitimacy of law. And some people, before I got to my own work on this, I realized some people just sweepingly explain the other effects of law as saying that people internalize the obligation to obey law, and without justifying my views, I'll just explain I was somewhat critical of the notion that people have internalized generally a duty to obey law, because my observation is that, at least around me, that many people violate many laws, and they obey many laws, they violate many laws, but it didn't look to me like a sort of general thing that people felt some strong internalized duty to obey law in general. So that leads us to think, well, maybe people have internalized the duty to obey specific laws, and this seemed right to me, but I didn't think that it could be the first explanation of people obeying the law, simply because, as a psychological matter, it seemed like people would have to obey a law before they could internalize it. I didn't really understand psychologically how people could not be obeying a law and then one day decide that it was internalized and start obeying it. Rather, it seems like they'd be obeying the law, and then after a time they would internalize it, and then that means that step one, we have to explain why they obey the law before they've internalized it, before we get to step two, internalization. And so that's what deterrence theory does, that's what legitimacy theory does, and that's what I pursued some expressive theories, which I'll just name a theory about coordination, a theory about information that were also intended to show how people who had not yet internalized a law could obey it. But then it occurred to me that the halakha does not require these expressive powers, because I realized I had been focusing on secular law, and the way I proceeded was perhaps made sense for thinking about why people would be influenced by secular law, but not necessarily by religious law, especially because you could simply explain obedience here as when you are not yet an adult, your parents tell you to do certain things, and if they're insistent, then you tend to do them, and if they are religious and getting you to practice religion as you can practice it when you're a child, then you tend to do it. And so then we could explain internalization that way. That is, as children, we start to practice the rituals and rules of our religion, and then we could come to internalize them, and then we don't have a need for any of these other theories of legal compliance, including expressive ones. So finally, against this sense of doubt, I came to think that there were some connections between the theories in the expressive law literature and this book. Some rules, I think, of halakha seem to reflect some expressive concerns That is, some ways of trying to get the law to influence behavior beyond the mechanisms of deterrence or religious-based internalization. And these are tentative ideas and outside my area of expertise. And I will also just say, at the beginning, this will be a marked departure from the first two panels in that I'm going to be thinking about these rules in a functionalist way. And that's just how I tend to see legal rules. Maybe that's why I'm at Chicago. And to be clear, let me just say one thing about functionalism. This does not have to be a theory of how the rules came to be. Doesn't have to be a theory of why the rules were motivated in the first place. It could just be that rules that are functional tend to last longer than rules that are not functional. That, the reasons the rules come into being has not selected because of their functionality, but when rules turn out to be dysfunctional, there's a push to get rid of them. And so functionalism can then exist alongside non-functionalist explanations, and both can have something true about them. So one example is that, of course, many of the rules here are about how to honor someone or something, how to honor the dead, how to honor the Sabbath. And this connected for me with what I described as law's ability to help people coordinate when they need to coordinate. And some of the examples of coordination I use in talking about law's coordinating function are extremely mundane, having to do with traffic and the idea that, if you want to avoid traffic accidents, you would like to find a way to coordinate, and you might like at an intersection to go while the other person stops, but if the law makes you think, if the law just proposes that you're the one who stops, then you might think that mere proposal will make the other person think that you will stop, and if the other person thinks you'll stop, then they won't stop, and if they won't stop, you do want to stop, and what do you know, you're obeying the law. But this works also with the need for coordination, to have a coordinated understanding among individuals for what it means to give honor to something. And again, a kind of mundane example compared to most of the discussion today, but I get to be the first person to cite a federal statute, 4 U.S. Code sections 5 through 9, describes how to honor the American flag, how to display the flag, how to store it, how to dispose of it when it is tattered, in a manner that pays the flag respect. Now, this statute caught my attention because it's purely expressive, because the First Amendment prohibits punishing anyone for not following the statute. Does that mean it has no function? Absolutely not. The statute likely affects behavior because there are some people who are motivated to honor the flag. And they might realize that without any, in a very large country, geographically large and with a large population, that without some centralized articulation of the rules for honoring the flag, that you could have divergent norms emerge in different parts of the country. And that could lead to a situation where people living in one town and two different towns follow different customs, and each of them looks in horror at how the other town treats the flag, thinking it's disrespectful, even though they're both motivated by the desire to show respect. So, the rules are, burning the flag is we think of a form of protest, but of course, as these rules describe, actually at the end of the flag's natural life, that's one of the honorable ways of disposing of it. So you can imagine that there's real possibility of disagreement. And the law helps to solve this coordination problem just by saying, here are the rituals of honoring the flag. And you could ignore them because there's no consequence, but you realize that other people will now interpret your behavior as honoring the flag, and so it helps you coordinate. Now, with the internet, it might seem all too easy to solve coordination problems like this among dispersed people who want to agree on a set of behaviors that show honor, but this was certainly a difficult problem for many centuries, when there would otherwise have been a tendency for local divergence. Just as there is in language, the appearance of a dialect may make it difficult for people who at one point spoke the same language to communicate. local variation could threaten the sense of unity within a single religion as to how to give honor to people and things and ideas. So that's one example that I wanted to give you. A second one has to do with an idea that Professor Meyer Dan Cohen long ago coined the term for of acoustic separation. And I don't think I understood how much Dan Cohen's ideas matters to law's expressive powers until actually after I read this book, and these things started to, come together for me. So just to explain his idea, he imagines that legal rules always have two audiences. Those who are directed to follow the rule, frequently the general public, and those officials who are directed to enforce rules by sanctioning violators. Now, in theory, we could separate the audiences, and if we did, we could separate the rules. And those directed at the public are conduct rules, and those directed at the enforcers are decision rules. And but why would we want to do that? In fact, we usually prefer transparency. That seems to be a value, and the idea of acoustic separation seems to make non-transparent to the people governed by rules how the enforcers will actually enforce them. And Dan Cohen agrees with that as a presumption that presumptively transparency is good, but he explores the exceptional cases where he thinks there might be some advantage to separating this out. Acoustic separation is a perfect acoustic separation is impossible, but he imagines that there could be some selective transmission of the rules. Now, one example he gives is the duress defense in criminal law, where critics of the defense worry that if people know they have a defense when they're pressured to commit a crime, they might too easily give in to the pressure and commit the crime because they know the defense exists. And so he imagines that, maybe the ideal would be to have a conduct rule where you just say, don't commit the following acts, they're crimes. You don't tell the people about the duress defense, but the decision rule, you tell the enforcers, by the way, if people are subjected to duress, don't bother enforcing the rules against them. And then they would hold out for as long as they could, and yet we wouldn't wind up punishing people we think don't deserve it or are undeterrable because of the pressure that they were under. So selective transmission might accomplish some good. I think we can generalize this point. In a way, law tends to be dichotomous. You're either married or you're not. The defendant is liable or he or she is not. We often, though, have the law as trying to influence behavior along a continuum where we would hope to not just to get people to stay on one side of the line, but we actually want to encourage them to do something as much as possible. We might decide that it's good for people to save water in a drought, or if they bear a duty to return lost property, the greater the effort, the better. But when that's true, then the dichotomous legal rule is somewhat difficult to use. I mean, if we set the standard very high and we demand a lot, then it might be a lot of people find it too costly and disobey the rule. But if we set it too low, it might be there's some people willing to provide more of the good behavior and will actually decrease their contribution. Some exemplary citizens who've been contributing far more than average without knowing it might then look at the new rule stating a minimum and realize they can cut back their efforts and still comply. So seen in this light, more generally, I think there can be an advantage to acoustic separation or at least the more possible selective transmission. Now, what does this have to do with halakha? Well, at first, maybe it seems nothing, because if it's a virtue to study the Talmud, then selective transmission is very difficult or impossible. If everyone knows the law, then there's only one audience. And yet, it seems to me that maybe some of the indeterminacy and open-endedness of the halakha might create something like acoustic separation. And here, I guess I'm following, Christine Hayes' view in reading the book to see in halakha a tendency at times to lead to perpetual uncertainty. And so consider how interesting I found it then when the one place in the book that discusses where the Talmud itself struggles with the choice of selective transmission. And in Chaim's book, around page 78, there's a question concerning the ritual of the showbread. And Rabbi Ami states that, quote, even if a person studied only one chapter in the morning and one in the evening, he has fulfilled the obligation derived from Scripture. This Torah shall not depart from your mouth. But then the Talmud addresses, but leaves open the question of whether this minimalist view should be taught to the unlearned. One opinion being that it is forbidden to teach this in the presence of the unlearned, and the other that is a commandment. This is the idea of acoustic separation or selective transmission. In this case, not to have a different rule for officials and the governed, but to have one rule for the governed who are learned and another rule for the governed who are not learned. And you might imagine that it perhaps could be a functional rule to distinguish between them. Perhaps those who study the Talmud can be trusted to do more than the minimum after they've already internalized the value of that. And those who are not already learned you might worry more about stating the minimum rule and what effect that would have on them. This would be very much like telling particularly manipulable individuals in society what the criminal law rule was without mentioning the defense of duress in order that they would hold out against pressure as long as possible. A final example, which I may or may not have time for.
We are at almost 17 minutes, but we will give you 3 more. Is that okay? 3?
Oh, yeah, I can finish more quickly than that. So there's a final example I wanted to talk about, which I think may generalize across some other examples. Around page 90 of the book, there's a discussion of the eating rights of workers. So that the employer has to provide some food during the workday for the workers. How much food? And there's some disagreement here. The sensible rule might be to give very limited eating rights as a minimum, just whatever the local custom is. But perhaps we don't want the statement of the rule of minimal eating rights to have the expressive spillover of lowering the food that some employers would otherwise have provided to their workers. We might like to have a conduct rule that demanded more, even though we have a decision rule that refrains from enforcement if the local custom is followed. But if everyone gets the rule from the same place, there's no selective transmission. So we might deal with this problem by having a vague standard, just that say that one must provide a reasonable amount of food, and that maybe that would work. The vagueness of it would cause some people to. It would stop you from lowering the contributions of people inclined to contribute more. But the problem is that some people are going to give less than is reasonable, so we want a specific rule that they can't go below, and yet if we do that, we signal to the employers that they can get away with giving less. So I found it interesting, the Mishnah states here the rule, but also states what, to me, sounds like a counter rule, that, quote, even a feast like Solomon's at the height of his grandeur may not be enough. So perhaps this creates a state of uncertainty that works to accomplish what I was describing a standard would accomplish. Everyone then knows they have to give the minimum, but many may be less than certain that giving just the minimum is actually sufficient. So we had Professor Hamundi refer to this idea in Islamic legal thought, where some people want to be safe and it wouldn't hurt to do more. And so maybe that is what is accomplished by having what I would call the rule and the counter rule that leaves some uncertainty. And so I am now out of time, but let me just say I've learned a lot from the book and from the other speakers today. So thank you.
There's a timekeeper right in the back there, so she'll hold on. Okay. 5 and 1.
Okay. Thank you, and thank you, Chaim, for writing such an interesting book and bring such an interesting group of people together to talk about it. I want to focus on something Chaim says in the book at around 27. If law is everything, then everything is law. And part of that is a descriptive account of the Talmud, that it contains within it serious explorations of education, theology, ethics, in addition to the more obviously regulatory aspects, which descriptively I find entirely persuasive. Knowing very little about the Talmud, you shouldn't take that too seriously. I find it persuasive. But it raises a puzzle. And it raises a puzzle that Tamara put her finger on, which is if what you're doing, if you're enjoined to spend all your time studying Talmud, and you have interests in philosophy or education or ethics, then of course you will find ways to do that within your Talmud study. But if you're not limited to Talmud study, is there advantage to do it within Talmud and within the legal categories of Talmud, or should one do it just, if you're interested in philosophy, do philosophy? And there, it seems to me, there's an interesting question as to whether there are advantages, whether you do philosophy better across some dimension if you do it within the Talmudic categories. But I want to focus on a more narrow question, which is this a good way to do law? In that sense, I really want to probe at the underlying jurisprudence of the rabbinic idea of law. And I want to really look at two issues. One is what jurisprudential commitments seem to be implicit here, and what do we think of them? And then the second is look specifically at the role of narrative in the Talmudic legal analysis. So there's a sense in which Chaim is implicitly comparing how we American legal academics and lawyers think about the law, and how the rabbis of the halakha thought about the law. I want to complicate that comparison a bit. The great question, or one of the great questions of jurisprudence of the last 100 years, can be summed up in the question of whether law is an autonomous discipline. It was what the American legal realists thought about. That's where they came into the picture and argued decisively, in their minds, against the idea that law was an autonomous discipline. What's meant by law being an autonomous discipline? The question is whether traditional legal materials, the statute, the cases, suffice to determine the outcome of the interesting legal questions. Now, for the law students in the room, if you think back, the first years are in class, but you have had first year. Think back to your first year curriculum, to the times where the casebook, where your teachers spend time trying to convince you that a good lawyer, in this case, could come out either way. That the cases, that the statute were susceptible, with good legal analysis, to coming out either way, leaving open the question, if that's true, what determines the outcome? And the standard answer I submit in American legal classrooms is something else. Sometimes it's called policy. Sometimes it's called market practice. But it's something else. If you noticed, your case books usually say cases and materials on the law of contracts. The and materials is your legacy of legal realism. It's the non-legal materials that Carl Llewellyn, Jerome Frank, Leon Green, that the great American legal realists thought were necessary to add into the mix in order to come to a sensible outcome. Now, contrast that, and Jeremy earlier in his talk explained why so many of his colleagues won't read Chaim's book, because on the halachic view, classic halachic view, the legal materials are sufficient. That law is an autonomous discipline, that within the classical legal materials, you can come to a resolution of the cases. Now, what stands in between these two polar kinds of approaches is the approach outside of the United States to legal analysis. So if you go to England, and if you studied law in England, you would get a very different kind of implicit jurisprudence. UK lawyers are brought up in a different legal culture and have an education that encourages the notion that the substantive debate, as in the halakha that Jeremy describes, should be carried out within the doctrine and using doctrinal categories. Parenthetically, part of the reason I think Dworkin is so popular among people who do halakha is that Dworkin purports to square the circle. Dworkin purports to stay within the general positivist picture that the cases and materials are sufficient, but he adds things like the best moral theory that describes the cases. And that allows you to bring in some additional factors that allow you to come to a determination. And Dworkin is amazingly popular among the at least among the Israeli and New York crowd that does this sort of thing. Now, you can get to the same result if you're a good lawyer under either system. And in many cases, judges will come out to the same place. But if you talk to people in the UK who do private law, the ones who are deeply convinced of the appropriateness of the UK believe it's a better way. It's a better way to proceed. And here I'm thinking of Peter Birks and his followers in UK legal scholarship who do unbelievably sophisticated doctrinal work. They know so much law. And the close reasoning is more than a little bit reminiscent of Talmudic discussions. And they bring this to bear on all sorts of topics like unjust enrichment, restitution, remedies, promissory estoppel. But when you talk to them, and this is something that comes out of doing comparative corporate law, is you find out that it's more than just the way they were raised. They have a positive belief that this is a better way to proceed. So how might it be better? How might it be better? It might be better because it's politically more acceptable or more legitimate. Judges doing social policy on its face, they're unelected, has a problem in its legitimacy. But judges just applying the law is consistent with what it is we expect judges to do. It might be better because it's more predictable. More predictable because lawyers read cases and you can sort of figure out where it's going to go, but social policy, who knows what people will conclude is the optimal social policy. It might be better aesthetically. There is something beautiful about really, really sophisticated doctrinal analysis. And part of what encourages or what people thrive on in the almost playful doctrinalism is simply displaying skill in this effort. And it might be better because it is more likely to arrive at the substantively correct result. And that's the argument I heard at this comparative corporate law conference I'm thinking about in Oxford. It's Rob Stevens, who now is back at Oxford, is a tremendously gifted doctrinalist, argues that proceeding doctrinally will reliably produce better results in focusing on policy. Why? Because judges are trained deeply in doctrine, and because much wisdom is embedded in that doctrine, that it is the accumulated wisdom of cases over decades, over centuries. And as a result, judges proceed more surely and intelligently and predictably when they proceed through traditional doctrinal categories and analysis than when they pretend badly to be economists or policymakers where they do not have advanced training. That, it seems to me, is the defense of the Peter Birks doctrinalism. And the question is whether that is similarly a defense one can make from the outside of halachic doctrinalism. That it has the same kind of quality. The challenge here, of course, is that part of the source of the wisdom embedded in decided cases is that it's applied law. That there are actually cases that come in front of judges and judges decide the cases and they accumulate. And so the challenge is with non-applied law. What does it mean to do better, and what sort of confidence do you have that the legal conceptual categories are the ones that lead you in the better direction. And here I come to a question that is almost a question about what's not in the book. And what's not in the book is any sustained discussion of what's called mishpat ivri. Right? Mishpat ivri is an Israeli movement many people associate with Menachem Elon, who wrote a book called The Handbook of Jewish Law. And it was a movement to plumb the Talmud for rules that could then be introduced into Israeli civil and criminal law, domestic law. And it proceeded, in most Israeli law faculties, there is a required course in Mishpat Ivri, in Hebrew law. And Menachem Elon's whole project was to come up with a whole bunch of rules from the Talmud that could then be implemented into civil law. Now, Chaim's book is deeply, deeply opposed to that project. Right? It is, without saying so. There are a couple of citations of Menachem Elon, but it's deeply inconsistent with that project. And I would have liked to have heard a bit more about it, because it's a project that I think has sort of run its course in Israel. Certainly the current generation of people who teach in Israeli law faculties view this as an ahistorical curiosity of a particular period in the state. So I think a question that comes up from Chaim's reading of what's going on in Talmud is whether this approach, this doctrinal approach, that purports to be much more like the Peter Burke's approach, much less like the American legal realist approach, what are the advantages of it? Does it lead to substantively better outcomes? I want to turn to a second question, which is prompted by this wonderful story in the section on halachic arguments in Agadic forms of the man who becomes infatuated with a certain woman, and what to do about that man. Years ago, I wrote a piece called Saints and Sinners: How Does Delaware Corporate Law Work?, in which I argued that the characteristic feature of Delaware fiduciary duty cases is long, very involved, very judgmental fact sections that describe the behavior in deeply judgmental terms, and by the end of which you always know who wins. The law sections, nothing's happening in the law section. Nothing's happening of any interest. All the action is in the fact section. And I described these as a sort of parables of good managers and bad managers, often with no sanction imposed, often expressive in the sense that Richard's using it. No sanction imposed, but quite clear who behaved well and who behaved badly. And I described it as a way that Delaware courts fill out the normative description of what directors and managers are supposed to do. When I presented at a workshop years ago at Hebrew University, and afterwards I was talking with Ruti Gavizon on the faculty there then, who was a very fine, was a student of HLA Hart's and a brilliant jurisprudent. And she made the point that she said, look, what you're talking about is standards, and she made the assertion that standards are always articulated through narrative. Now, let me excavate. One of the contrasts in typical legal academia is between rules and standards. Rules are like what you see in the Internal Revenue Code. Very detailed, ex ante, upfront, forward-looking specifications of conduct, whereas standards, like the reasonable person or good faith, are ex post determinations that a particular person behaved properly or not. And her point is that standards, these ex post, backwardly looking determinations, are intrinsically through narrative. Sometimes standards get codified into rules, but that the classic standards are, the term good faith is really standing in for a set of cases that any practitioner in the field knows. And the question I have about in reading Chaim's description of halakha is the question of what is the role of standards? And what's the role of narrative in the articulation of those standards in the Talmud? That the story about the infatuated man, not exactly clear whether that or the other sort of narrative forms, not exactly clear whether that's either a parable of a good guy or a bad guy. And more generally, the question is are there parables in the Talmud? That is to say, parables in the sense of these instructive narrative tales designed to fill out the normative description of a particular role. It's the same question of are there standards? And part of what's so interesting about the discussion so far is descriptively, it seems, and maybe this is the result of decades or centuries of intense focus on these fine descriptions. But it seems that the Talmud, as described, has an extraordinary affection for rules with relatively little attention to standards. And if you think about this from a domestic law, civil law sort of perspective, that's kind of odd. There are two different ways, there are two different technologies. Standards, rules are expensive up front. You have to specify the SEC has 4,000 employees. The Delaware courts have 12 judges and 2 clerks a judge, right? Standards are cheap in that regard. On the other hand, they give less specificity until they build up over time. So let me stop there with those questions. Thank you.
All right, so first I'd just like to take the opportunity to again thank Chaim for including me in this wonderful conversation, also for remembering little bits of conversation from over a decade ago that reminded him that I might actually be interested in this, as well as the Villanova Law Review and the law school for hosting all of us. I'm personally grateful for the opportunity to be able to grapple with this brilliant book and to be able to talk with all of you about the insights that we can glean from it. For me, at least, one of the powers of the book is that the arguments are somehow both warmly familiar and bracingly new, and it's, for me, just fun to be able to kind of think through the implications. Now, I've been asked to bring in a perspective from outside of this discussion, specifically from international law. This topic, as it is for many of us here, is a personal one for me. I am a Jewish professor of international law at the University of Georgia who holds a professorship named for a former colleague, Gabe Wilner, who is also a Jewish professor of international law at the University of Georgia, and continuing a tradition of international law at the University of Georgia started by Sigmund Cohen, a refugee from Europe and the first Jewish professor at the University of Georgia. And there's nothing unique about this, right? It's been widely noted that an unusual number of the most prominent, most important international lawyers of the 20th century seem to have been Jewish, including people like Hirsch Lauterpacht, the giant of mid-century international law who advises Robert Jackson and the UK team at Nuremberg, who is a founder of human rights law and sits on the International Court of Justice, or Louis Henkin, the Columbia law professor who almost single-handedly writes the Restatement Third of Foreign Relations Law. Henkin used to tell the story that as a Supreme Court clerk, in order to avoid traveling on the Sabbath, he would secretly sleep on Felix Frankfurter's couch. There's also a personal connection here, too, because Louis Henkin's son was actually the music director of my camp and my children's camp. But the list can go on much longer. We can name lots of other people who one might put on this list, and this has led many to try to find something Jewish about modern international law, whether it's just a kind of emotional cosmopolitanism or something deeper. But from a deeper theoretical perspective, my interest in this topic actually goes back to law school, when H.L.A. Hart reached out from my copy of the Concept of the Law and slapped me in the face. Primitive law was how he described both the law that I had first learned. I went to a Jewish day school, and international law, my newfound academic interest. And while I've tried not to be insulted and to embrace my identity as a primitive lawyer, your legislature, courts, and police confuse and frighten me. But one thing I know is that my client is innocent. I've always felt like there was something about my training and lived experience in the first of these two primitive laws that helped me understand the second of them, and that together somehow Jewish law and international law unlocked aspects of the concept of law that Hart's definition missed. Now, having read through Chaim's brilliant, decisive book, I can't help feel that my instincts were right. Throughout, I was struck by various parallels between his description of halakha and developments in international law. I want to be very careful, though, both not to draw sort of bad causal stories or to draw false parallels. One of the best aspects to me of Chaim's book is that he makes halakha weird. That's a good thing. He draws out the idiosyncrasies of it. He doesn't try to kind of naturalize it to other areas of law. And I don't want to flatten those idiosyncrasies through comparison. So instead, what I want to do is to sketch out some themes about international law, international legal theory, and its development that I think the book evokes or surfaces. Okay, so some themes. So the first theme that I think this raises is something that you might call international law's sociology and the sociology of international law. One of the peculiarities of international law is that at its origin, right, when we first start seeing sort of modern European international law, or then the law of nations, it's playing a game of catch-up. If you look at the early modern theorists, whether it's the Jesuits, Vittoria and Suarez, or after them, Gentili, Grotius, and Hobbes, as they see it, they're trying to explicate, explain, understand a phenomenon that's already out there. Right? They're looking at a world in which states, as far as they see it, are following rules in their relations to one another. They want to understand what those are and why they do it. And this sort of sociology, right, that they're engaged in pushes our ideas about international law in particular directions. It tells us where to look for international law. It tells us where to look for authority. And it tells us what counts as law in weird and quirky ways. So first, for example, you find in international law very early on that there is an intense focus, an almost obsessive focus on practice. Right? If you look back at the early modern writers, they're looking at Greek, Roman, biblical, medieval, and early modern practice, but this continues to today, where we debate at length the meaning of the 1837 Caroline incident and what it tells us about self-defense against non-state actors, or the assassination of General Yamamoto during World War II and what that tells us about the laws with regard to targeted killing. And we look at these incidents, these particular moments of practice, with the same discerning eye that we might look at the story about a rabbi traveling to a different town and leading services a certain way. And the role of practice is so dominant that we actually have incorporated it, codified it in the actual sources of international law, both in the evidence of customary international law, but also in subsequent practice and its role in interpreting treaties. But of course, practice is and was hard to find. This leads to another quirk, which is the turn to great writers or publicists of international law as sources of authority themselves. So if you look at Grotius and Gentili, they're reading Cicero, Tacitus, Livy, and the Bible. Hobbes famously translated Thucydides. And if you go on beyond that, right, you start to see others going back and citing these thinkers. They might then add to them people like Emmerich de Vattel, the Swiss theorist, whose work becomes particularly foundational for the founders of the American Republic. If you really want to show off, you might start using names like Binkerschock and Pufendorf and Wolff. But today this continues where you might be using names like Lauterpacht and Henkin. And again, what's strange here is that these are not just sort of appeals to authority in a very general sense. We've actually found ways to incorporate this directly into our understanding of what the rules are. Right? So we don't give the treatise writers, the great publicists, the same status as, say, custom. It's not a source of law, but it is actually codified as an ancillary source of a agreed-upon form of evidence of what the rules actually are. But most of all, this sociological inclination creates unique approaches to the ultimate sources of authority and law. Where does this practice get its normativity from? That becomes the big question for all of them. For Grotius, right, the answer is right reason. It's a kind of marriage of customary practice and natural law. Right? The argument is that in these patterns of practice that we see in the world, we see evidence of what the laws of nature must require. Vattel develops a more complicated schema, right? A hierarchy where you have the law of nature on top, followed by the voluntary law of nations, which is not voluntary at all, but is derived from the law of nature. You then have the conventional law of nations, which are treaties, and then custom. And this marriage of practice and natural law is so strong that even as international legal theory moves into a kind of more positivist mode in the 19th century, where you have a rise of contractarian notions of international law, where law is what states agree to, and a focus on treaties, these ideas don't go away. And we see this today in the continued force of rules like jus cogens, peremptory norms of international law that you cannot contract around, but which no one can really say where they really come from. General principles of international law, notions of good faith that are strewn across various different doctrines of international law, as well as appeals to humanitarian concerns as treaty gap fillers. All of these operate as sort of natural justice backstops of international law. But more importantly, international law sociology makes an accordion-like concept that can be narrowed to more formalist notions of black-letter law or widened to include political philosophy, economics, and international justice. We might be looking for international law in cases, treaties, or treatises, or we might be looking for it in Hobbes, Kant, Weber, and Habermas. And this is because historically, international law has been as much about exploring the nature of the ideal international community, the ideal international law, outside of what any state has ever done, as it has been about discerning the rules of the system. And in a sense, it's this tension between these two visions that allows international law to find some equilibrium between apology, merely being a codification of what states do, and utopia, the idealized set of rules that states have to follow even if they don't consent. Okay. So a second theme that I think that this surfaces is one with regard to secondary rules and the rules of recognition. Right? So going back to Hart's insult, right? For Hart, the big question for international law is in the absence of clearly demarcated officials or codes, right? Who's going to tell you what the law is? And here, international law returns back to practice and authority. We learn the rules through practice, and authority is judged by craft. Right? In my own work, the model I've used to describe this is the community of practice. Right? The idea here is you have groups of individuals who come together based on a commitment to work together through common sets of tools, methods, and resources. Right? Hart talks about going to the officials to look for the secondary rules. Well, in international law, they're officials, but they're not in a vertical relationship with one another. They're in a horizontal relationship with one another. It's what Oscar Schachter famously referred to as the invisible college of international lawyers. It's their arguments that construct the rules, as well as the space for future arguments. The rules are developed through an ongoing dialectic, and they're subject to constant community testing. And that testing turns on notions of craft, one's knowledge and ability to use the interpretive moves and rules, the ability to properly wield lex specialis and lex generalis, jus cogens and erga omnes, evolutive interpretation versus object and purpose, as well as when to invoke Nicaragua or Tadic or Vattel. Right? To a certain extent, the extent to which you are recognizing these terms tells you how close you are to the center of this community of practice. But basically, in this realm, officialdom, right, the difference between Lauterpacht and Cohen is constructed by craft, is your ability to actually wield these terms in ways people understand. You might imagine the legal community in this sense as a set of concentric circles focused around particular loci of practice. So if you think about it in international law terms, you might imagine at the center here certain international organizations or a court or even the court of public opinion. Right? And at the center around this particular forum, you're going to see kind of a concentrated core of specialized actors who practice with each other on a regular basis, right? Who are engaged in kind of constant practice. Outside of that core, you're going to then start to see other groups of individuals who will have less interest in the practice or will practice less often, but still share a commitment to both the practice and the operating rules, tools, and methods of that practice. And while these groups who are farther and farther outside of the core may not be as deeply involved in the practice, they are involved in the community testing to the extent to which they no longer accept the legitimacy of the practice going on at the core. We can say that they're no longer part of the community of practice, right? They've fallen outside of it. So in a sense, in order to retain them in the community of practice, even those at the core need to be aware of kind of the community testing that they're doing. Now, over time, right, we would expect, right, that as needs require, you're going to see the fora around which these practices engage. We expect them to see them multiply. Right, schools are going to grow up, courts are going to come into existence, other specialized areas are going to come into being, and as that happens, right, we're going to see practice develop around those areas and possibly diverge from what we saw at the original core. We might start to see competing centers of practice. And this leads you to what becomes the emblematic millennial concern of international law, fragmentation. Right? The anxiety of international law around the millennium is whether or not the invisible college can survive the advent of the WTO, the International Tribunal for the Law of the Sea, the International Criminal Court, investor-state dispute settlement, and the specialization that comes from all of that. But what we've seen is that as time has passed, fragmentation fears have subsided as new cross-field dialogues and consensuses have emerged. What this highlights is the very ambivalent role of pluralism in this horizontally constructed system. Pluralism is both a threat and a source of reform and renewal, while the inability to fully control interpretations, the inability to wield the acts of jurispathy makes international law difficult to control and may even weaken its enforceability. It also provides a protection against calcification, a hedge against codification, a way to introduce new interpretations in the absence of a legislature, and a repository of counter-narratives of law that were otherwise smoothed away through dispute settlement. Basically, how we manage pluralism is how we manage legal change. Finally, one last theme here, what I might call from negotiated law to adjudicated law, or from arguing to administering. As transnational connections have spread and deepened over the past century, the demand for specific administrable rules around which everyone can plan has increased, along with a drive towards codification of international law. This has led to two opposing phenomena, the first being judicialization, and the second being soft law. Each of these brings various benefits, but they also raise serious conceptual and legitimacy challenges. So take judicialization first. Prior to the 20th century, courts and adjudication were relatively rare in international law. To the extent to which they existed, they were ad hoc arrangements built around compromise, or they were the operations of national courts who had their own projects in mind. Instead, the way the law was hashed out was through jawboning, dialogue, disagreement, eventually through some sort of compromise settlement. Now, the modern judicial revolution has allowed disputes to be resolved more peacefully, to shift the balance from power to justice, and for more systematic and organized rule development, but it's also raised serious questions of legitimacy. Right? As their work has exploded, many have started to ask why these investment arbitrators, or those WTO appellate body members, or these ICC judges should have the authority to interpret the law for everyone at all time. This concern is heightened by the fact that it's so hard to legislate in the community through treaties or custom, but it also raises concerns that judicialization might eliminate the give-and-take ambiguity that has formed the lived life of international law. On the flip side of this equation, right, facing the same difficulties with regard to agreeing on hard legal rules, international lawyers have developed other forms, non-binding UN General Assembly resolutions, best practices, voluntary codes of conduct, interpretive guidances. This international law sub-halacha, or minhag, is super useful. The problem is that, like sub-halacha, soft law has a tendency to harden, and with this hardening comes questions of legitimacy. Moreover, because we know that it has a tendency to harden, soft law then becomes a competitive activity where everyone tries to pass as much soft law as they can, instantiating their desired rules in hopes that they will then be able to take over the meaning of these interpretations. The upshot is that international law has a machinery that's been built on legitimization through jawboning and argumentation. We can imagine all sorts of new forms of rulemaking that might be able to fill various gaps. It's much harder, though, to graft onto this system different forms of legitimization. Or to put it in different terms, in the absence of a true international community or an international demos that might legitimate harder, deeper rules, international law itself remains essentially law in galut, or in diaspora. So with that, I'll end there.
Good afternoon. I too want to begin by thanking the Villanova Law School and the Villanova Law Review for having me here. It really is an honor. I also want to begin by congratulating Chaim on this beautifully written, completely absorbing, and as it happens, deeply meaningful book. I knew I was going to love the book from its opening pages. There, as those of you who have at least begun to read the book will have seen, Chaim describes the bewilderment he experienced as a 10th grade student being initiated into the mysteries of Talmud. And perhaps surprisingly, I know a little bit about this experience. So like Chaim, I also was in 10th grade in 1990. I'm dating myself. And I too was introduced to a whole new level of Talmudic instruction in that year. Now, unlike Chaim, my own introduction came not at the hands of yeshiva rabbis. I was at a co-ed Jewish day school in Montreal, where we were informally in training, not to ascend to the hallowed realms of Talmud Torah, of Torah study, but instead to the profane but no less revered realms of the only other two worthwhile vocations in the eyes of Jewish parents, medicine or law. For that reason, the only subjects that the school took seriously were math, science, and then, somewhat surprisingly, Talmud. So the emphasis on math and science I understood, these were prerequisites for medical school, but the emphasis on Talmud was completely obscure to me. We learned nothing that seemed at all relevant to teenage life, certainly nothing as titillating as what Chaim describes in the opening pages of the book. Instead, for us, it was all arcana all the time. I should say, though, that as a result of reading Chaim's book, I now appreciate that there was a method to the madness of exposing us to the intricacies of Talmudic reasoning. After all, if you weren't going to be a doctor, God willing, you should at least be a lawyer. So my mother put it anyway when I decided that I was not just going to pursue a PhD in philosophy, but I was going to respectably add to that a law degree. So thank you, Chaim, not least of all for allowing me to recover the rationale for this part of my education that seemed so baffling at the time, but that I now see, again, in no small part because of the book, as tremendously valuable. So I'll turn now to my more formal comments, wherein I want to address a particular strand of rabbinic reasoning that Chaim doesn't call attention to, but I think is worth underscoring. So the thoughts that follow stem from an effort in my years as a law school student to see whether moral particularism, this is a position about which I will say more, could be used to adjudicate between different legal theories. Now, that project might have been misguided in the first instance, but I return to it now in the spirit of the Talmudic rabbis, commenting, refining, and revising earlier thoughts. And I aim to argue that any successful theory of law should accommodate the insights of moral particularism, and that halakhic law does so. So to establish as much, I'm first going to describe moral particularism. I'll say why it's important that a legal theory not run afoul of the moral particularist's insights, and I'll use one of Chaim's examples to show how it is that halakhic law aligns with moral particularism and to draw parallels between it and Ronald Dworkin's theory of legal interpretivism. So what is moral particularism? The central thesis of moral particularism is that normative reasons function holistically. That is, whether they count in favor or against a particular act depends entirely on the context in which the act arises. So a normative reason is a reason that counts categorically against or in favor of a particular act in particular circumstances. To say that the reason counsels categorically is to say that it so counsels, no matter who one happens to be, what one desires, what projects or commitments one has, and so on. An ethical generalist, this is the opponent of the particularist, so an ethical generalist, most moral philosophers are ethical generalists, think that normative reasons always point in the same direction in all circumstances in which they make an appearance. So, for example, that an act X is painful, the ethical generalist would say, is always a reason not to X. Now, the ethical generalist can allow that other considerations outweigh the painfulness, such that one has all things considered reason to perform an act that involves pain. For example, ripping off a Band-Aid or relaying certain truths can be painful, but the pain is sometimes outweighed by the good consequences of these acts. And where it is outweighed by the good consequences, one has reason to rip off the Band-Aid or tell the truth. The important point to notice about ethical generalism is that pain always has the same polarity or valence. That an act would cause pain is, for the ethical generalist, always a reason not to perform that act, even if it's not a decisive reason. The moral particularist, by contrast, holds that the fact that a normative reason can point in favor of an action in one context does not entail that the reason counts in favor of the action in all contexts. So to illustrate with a favorite example of the particularist, that why would bring pleasure often functions as a reason that commends the pleasure-bringing act. So, for example, eating an ice cream cone would bring pleasure. That it would bring pleasure is a reason to eat the ice cream cone. But suppose now that we're contemplating an act that would bring pleasure, and the person to whom the pleasure would be brought is a sadist, and the pleasure-bringing act is an act of torture. That it would bring pleasure to the sadist if another person were tortured is not a good-making feature of the torture that is outweighed by its pain. The prospect of pleasure for the sadist actually tips the balance further against performing the action. Or here's a second example. That a course of conduct would be aggressive or cunning is generally a reason not to pursue that course of conduct. But think now of the zealous trial advocate. His aggressiveness or cunning is not just something to be tolerated. It's not just an unfortunate means to the positive end of effectively representing his client. Instead, in the context of trial advocacy, aggression or cunning are in themselves qualities that take on a positive valence. So in short, the insight of the moral particularist is that it is in the nature of moral properties that they do not have a fixed polarity. A given moral consideration might often count in favor of an act, but it need not do so in each and every context. The valence or polarity of moral considerations can shift depending on the contexts in which they arise. All right, so what is the relevance of moral particularism for legal theorizing? I believe that moral particularism poses a profound challenge to various legal practices, not least of all the doctrine of precedent, analogical reasoning, or even reliance on fixed principles. I should say that all of these practices are central to the law, and that moral particularism poses a challenge to them would seem perhaps to tell strongly against moral particularism. But in point of fact, I think what moral particularism demands is not that we abandon these practices, but instead that we treat them more loosely than we do now. In the interest of time, I'm not going to say more about moral particularism's implications for the law writ large. Instead, in an effort to domesticate moral particularism, I want to demonstrate how the law, both secular and halachic, is already sensitive to moral particularism's constraints. So to that end, I'm going to turn to discussions of compromise in both Ronald Dworkin's work and halacha to show that, at least with respect to compromise, both align with the particularists' insights. So in general, we might think of compromise as a virtue when it comes to resolving disagreements. That is, we can take the following as a rule of thumb, that a decision would involve a compromise is often a reason to favor that decision. But note that the fact that a decision would involve a compromise is not everywhere a reason that counts in its favor. Indeed, sometimes compromise is a bad-making feature of a decision. It's a reason that counts against the decision in question. We can see this in Ronald Dworkin's discussion of integrity as a principle that should guide legal interpretation. Dworkin aims to explain why compromise is sometimes morally desirable, but at other times not just outweighed by other considerations, but bad in itself. Consider in this vein his discussion of compromise for issues generating sustained political disagreement. Take, for example, the death penalty. Given the deep, intractable divide over the moral permissibility of the death penalty, one might have thought that the law should reflect a position of compromise. For example, by allowing executions for all convicted murderers, except those born in a particular calendar year. But now, compare that policy, a policy that prohibits executions except for individuals born in a particular calendar year, with a policy that allows executions only for those who undertake mass shootings in cold blood. The death penalty opponent might well prefer the mass shooting exception to the calendar year exception, and this would be so even if more executions would result under the mass shooting exception policy than the calendar year exception. But then we should ask, why should the death penalty opponent prefer the policy that yields more executions? That is, the policy that would restrict the death penalty to mass shooters. The problem with the calendar year policy is that there's no principal justification the state can offer to explain why some convicted murderers escape the death penalty and others do not. The demand for principal justifications, Dworkin tells us, is a demand for integrity. Put differently, whereas compromise may count in favor of legal decisions in scalar contests, for example, about how much money to devote to the poor, where we strike a midpoint between those who want to give nothing to the poor and those who want to give a lot. Those are scalar contexts. Compromise counts against legal decisions in what are called checkerboard contests where some people will be absolute winners and others absolute losers. It's better that all should lose than that the state should bestow wins on no meaningful basis at all. This is the outcome that moral particularism mandates. For that outcome respects the variability of moral concepts. The law understands that thick moral concepts, like compromise, behave just as the moral particularist expects them to. Interestingly, and as we know from Chaim's book, compromise operates in just this way in halachic law too. To take one of the examples he offers, consider the biblical story of Joseph. Joseph, whom Jacob loved best of all his 12 sons, is sent to retrieve his brothers, who had traveled with their sheep to pasture far from their father's home. When Joseph arrives, the brothers decide to act on their roiling jealousy of this golden child. They dig a pit and plan to leave Joseph for dead, until one of the brothers balks, insisting that they save Joseph. A second brother, Judah, steps in to broker a compromise. Judah proposes that they sell Joseph into slavery. This will spare Joseph's life, but still inflict immense hardship on him. On its face, and as Chaim describes, Judah looks to be the hero of the day. He spares Joseph's life. But two facts make Judah's intervention, which results in Joseph's enslavement, not just wrong on the whole, but indeed worse, because it involves compromise. First, note that selling Joseph into slavery earns Judah, along with his brothers, money, whereas killing Joseph would have earned them nothing. As the Bible recounts, Judah prods his brothers by asking, "What will we profit by killing our brother?" This is a brokered, self-serving compromise. Whereas preventing Joseph's death might have mitigated the guilt Judah bears for selling Joseph into slavery, the fact that Judah is motivated by profit enhances his guilt rather than undercutting it. Normally, it's good to lessen the harm one inflicts on another, but when weighing Judah's responsibility, it's not that we subtract his self-interest from the goodness of his preferring enslavement to death. His preferring enslavement to death ceases to be good at all, because the preference results from nothing more than base self-interest. Here's a second way that compromise is aggravating rather than mitigating. Suppose that murdering Joseph had never been on the table, and Judah had proposed out of the blue that they sell Joseph into slavery. In that instance, there would be no counterfactual to weigh against his slavery proposal. We couldn't say, well, at least he saved Joseph from the worst fate of death. So Judah would incur the full force of our blame for having sold his brother into slavery. Now return to the story as it unfolds. Slavery is the lesser of two evils, the other one being death for Joseph. Why should Judah get credit for retreating from the worse evil of killing Joseph? Choosing the lesser of two evils counts as a compromise that mitigates guilt when, but only when, one is forced to choose one or the other evil. It's no mitigating factor if one could have chosen not to pursue evil at all. Instead, in that case, choosing the lesser evil just highlights one's bad character, for it shows one to be willing to transgress even though one was fully free to do otherwise. The lesson for us is this. As in Dworkin's discussion, halacha recognizes that morally thick concepts can change valence, depending on the context in which they arise. Nor is compromise the only halachic concept that operates as the moral particularist thinks it should. Simon's book is rife with examples. The moral meaning of manliness shifts in the pre-messianic and post-messianic stages. The relative priority of animals' interests shifts depending on whether the animal belongs to one's friend or one's enemy. The moral valence of resources shifts depending on whether they were justly or unjustly obtained. I don't have the time, obviously, today to describe all of these examples, but suffice it to say that as a result of Chaim's work, I'm convinced that the rabbis, whether known to them or not, were moral particularists through and through. And I look forward to exploring these connections at greater length. So let me end by saying what a great pleasure it was to rediscover halakha through Chaim's book and to see in it resonances with much of the thinking that I've undertaken since my own early encounters with Talmud. So thank you, Chaim, and thank you to all of you.
Thank you all. That was wonderful. And so timely. So we're back on schedule, and we have time for some questions, which I didn't anticipate. So in order to try to get us a little bit closer to schedule, let's do just 5 minutes of questions. So I'll throw it out to the group. Does anyone have questions? Yes.
This question is...
Oh, and here I've got this, so that people who are watching on the live feed can hear you. Don't know how to turn it on. Does anyone know how to turn it on? Never mind. Talk loud. Never mind. We're good. Okay.
So this question is directed at Professor Cohen, and of course anyone else who would like to chime in. So as we've examined sort of the parallels and distinctions among Abrahamic religions and across various legal theories, and of course after reading Professor Sagan's book, I can't help but wonder if this symposium itself has been sort of a Talmudic exercise. That's a word or a term. If I'm using that correctly, close enough. So, because we're teasing out sort of universal general principles through the discussion of specific intersectional details. And I feel like this process has allowed systems of rules to develop and evolve over time and allows us to gain a greater understanding of human nature. So with this in mind, do you think that systems of law are purely social constructs invented by humans, or do systems of law sort of pre-exist our understanding of the law? So, in other words, with respect to the process of developing legal systems, is the law invented or is the law discovered?
Wow, I'm not sure that I'm qualified to fully answer that question. I mean, there are various different ways that one can approach that. So I've always I have some colleagues who are staunch Fullerians who believe in the internal morality of the law and that there are very specific things that are natural to law that you would have to see across legal systems. And we both work with communities of practice, and we talk about this a lot. I've always taken the position that I'm agnostic as to whether or not the internal morality of the law is something that is natural or simply something that is common. I don't know how to answer the question, right? If it's simply a historical cultural reality that we have certain notions about what gives law its lawness, or if it is something that has a deeper morality to it, I don't know. But I think it raises more interesting questions about thinking about about how we have over time constructed notions of law and legality. And so I guess the question we have to ask, it's a little different from the one that I was sort of presenting and sort of thinking about some of the commonalities between international law and halakha, is rather to think about across all these things that might make these different legal systems different, do we see that there are common methods for approaching authority and law that we would see across them? I think the answer is probably yes, but I think it would require a much longer answer, and maybe others have ideas on how to answer this. One thing that I do think is interesting across these various different areas is there is a relational quality to the law that is surfaced by halakha and by international law. It's not where you see very clearly that the law exists not in sort of the relationship between a particular code and a particular code follower, but the relationship between various different actors who wants to figure out what law means to them, and they have to sort of interact over that. To the extent to which that is something common might be something interesting to explore.
Does anyone else want to take a shot at that?
Corporate law is invented.
Hart was right. No. Oh.